I know little enough about the professional qualification of social workers, and I think that's true of many people in my position. I think that's quite an interesting point that I found, having looked at the research material you've done, that there is an absence of knowledge, both by solicitors and the judiciary, about quite what the training of social workers are.
It needs to be established between the local authority lawyers and the social worker, in a sense, how the social worker is to come across in court, because normally you would just expect them to talk about social work issues. If a lawyer wants to bring out that Miss So-and-so has got a qualification in X expertise, then I think it's vital it should be stated by the social worker right at the beginning, and indeed the local authority lawyer ought to make it clear to the judge from the beginning that he or she wishes to use the social worker for that purpose.
In terms of where to use an expert and where to allow the social worker to carry on with their expertise, that's always been a difficult issue. I think the magistrates have been very helpful historically to the local authority, in that they have very often objected to other experts being involved because of cost, because of time. And there is some work to continue with the magistrates, but my view is that the real problem lies with the higher courts, and I have had a number of experiences where we've been told that the social work evidence would be insufficient, and that we need to have an independent social worker to deal with matters such as attachment, which we strongly disagreed with, but the court didn't rule in our favour.
The court is doing its job. No expert is brought into a case unless the court authorises it. Now, there may be occasions when a judge, under pressure of time, simply signs off an agreed order presented to him by the parties, which provides for the instruction of an expert. That shouldn't happen. That should be the judge's decision that an expert is brought into the case. One of the troubles we have got into with care proceedings is that we have used too many external experts, not only for things they need to be used for, but also as a substitute for social work. And that's been very, very damaging, because it has undermined the role of social work. And the protocol, which came into force in November 2003, has given the social work profession an opportunity to recover some of the ground that it has lost.
Everybody is aware, certainly locally, of a real concern about the use, particularly, not of experts per se, but of particularly psychological and psychiatric evidence. I think it's less controversial, the expert evidence that's used, for example, in medical evidence, although I may be alone in that. I certainly think in terms of non-accidental injury and those sorts of matters, use of experts is less controversial, because it is a more defined expertise that's necessary and clear, or more clear, for the court.
When you consider which type of expert you should be appointing, and indeed whether they will be appointed, I think it's useful for all parties to bear in mind how useful or otherwise experts may be. If it's a piece of work that perhaps the social worker could conduct, it will mean that they continue to remain driving and being involved fully in the case. In a recent case that I've been involved in, a psychologist has indicated that father poses a particular risk. However, the guardian, the parent and the local authority don't necessarily agree with the level of risk that's been put forward by the psychologist. But unfortunately, the psychologist won't move her position or won't re-evaluate father. What we're now left with is effectively the expert who is driving the case, and it's the local authority who is saying that they can't ignore the advice of the expert, but that advice is effectively pushing them down a route that they don't want to go, and that route is adoption.
There is only one order that can be made by any court of any jurisdiction which is more far-reaching than an adoption order, and that is the order which can be made by a High Court judge authorising the doctors to switch off the life support machine. An adoption order doesn't just affect mothers and fathers, it affects the grandparents, the uncles, aunts, cousins and sometimes siblings with whom a child is born, who cease to be grandparents, uncles, aunts, cousins and siblings, and it creates new grandparents, uncles, cousins, aunts and siblings. It is the only order about children that I make which goes on after the age of 18. It goes on throughout life, and it is the only order which cannot be routinely varied or discharged as care orders, residence orders, contact orders can all be changed while the child remains a child. It's a very far-reaching order, and social workers need to recognise that when they're in that jurisdiction.
I think that there's been quite a lot of local discussion, I think, about the use of psychologists, where they become elevated, I think, in their use, both as to the extent of their use and as to the reliance that is given by the court to that use, so that on occasion one would find that they're asked, I think, questions beyond their remit that are so clearly within the remit of social workers. Because we are calling them, we kind of utilise them very greatly in the whole gamut, so they're asked all sorts of areas that might be considered historically to have been very much the expertise of social workers and indeed guardians, about the relationships between children and parents in particular, about contact issues. So I think that there is a reliance upon experts, and the more that goes on, the less the de-skilling system occurs with social workers. They feel less able to cope, and they know that the judges and the judiciary have got an expectation that it's going to be dealt with at a different level. That seems to be my experience.
We have to draw a distinction between the type of experts that we're talking about. And I think that medical experts, doctors, bone experts, those sort of people are a completely different kettle of fish. We need them, we can't do without them, and we need to be informed by what they say. But I think that in particular psychologists do overlap very greatly with the work that we could and should be expecting social workers to do. And I have noticed in recent years, probably the last 3, 4, 5 years, that now social workers are coming to court. When we have the advocates meetings and case management conferences, social workers are coming to court and saying, well, I think we might need a psychological assessment on this one, to look at the family dynamics, to look at attachment, to look at prognosis for change. And I know that local judges have been quite surprised in the past, but are getting more used to the idea of social workers and the local authority coming along and saying, well, yes, we agree there should be a psychological assessment. In the past, when you're representing for a parent, you want to go along to court and say, oh, I need a psychologist here or an independent social worker on this case. And very often the local authority will say, no, we don't need it, we've got this work. But now, say, when I represent the local authority, very often the social worker comes in and says, not sure about this, not sure I want to poke my head above the parapet, I think is the reality of it. And so judges are signing orders which say, yes, we'll have an expert. And the judges have stopped questioning it, and we've stopped questioning it. But I think that there is a lot of work that social workers can and have done in the past, and ideally should be doing really now in the future.
There's a huge problem in the courts at the moment about how far to use external expertise evidence and how far to derive it from the people who are inevitably going to be in court, such as the social workers. I think it's a difficult problem, and I think it needs to be looked at on a case-by-case basis. I mean, there are some cases where you say clearly need an expert, that there's no argument about it, but there are other cases where it's a much more iffy matter, and there's expert evidence and there's expert evidence. I mean, it's a bit like being a GP or a doctor. They've all got a basic understanding of how the human body works, because that's their training, and it's the same for social workers with the type of work they do. But you would no more expect a GP to talk about brain surgery than it seems to me, in fairness, you really ought to require a social worker to talk about areas which are difficult and are evolving, such as attachment problems. And I think really there, for example, you do need to go off to a proper expert. It's not to say that a social worker can't say, well, you know, I've seen how this family's developed, I've seen the sort of problems that have arisen, and I can see the sort of attachment issues which I, as a social worker, can talk about. But I would be reluctant to use them for more than that in that area. On the other hand, where it comes to sort of more general matters, which can include a degree of sort of child psychology, because again, they've seen how the child has evolved, I'd be much more prone and would much more wish to use them than perhaps they're being used at the moment. I mean, I do think, and it's on a slightly different subject, that with the new public law outline, when it comes into being, that the social workers are going to have a much more important role to play than even that which they're playing now. And if they play their cards right and they're properly financed and they have the chance to develop their cases properly, I do think that they are going to take over quite a lot of the expert evidence that we're getting at the moment, because so much more will be prepared in advance of the first hearing.
In an ideal world, I would like to see social workers live in such a way that they had time in their working lives, built into their working lives, to read up on research.